Okay, everybody, welcome back. So this is our last session before lunch. Again, just a reminder about the code of conduct and any questions, if you can put them in the Q&A box as well. So we've got Nick with us, Nick Cooper, who is an NASUWT senior official for our legal and casework team. And he's here to give us our latest updates around equalities case law. So I'll pass straight over to you, Nick.
Thank you very much. Good afternoon, everybody. Pleasure to be with you again, if indeed you have been here before for one of my sessions. As Claire said, my name's Nick. I work in the legal and casework team. We deal with tribunal claims. We deal with all sorts of legal claims. We provide legal advice and assistance to our caseworkers and ROs, and do research and things like that into legal matters. I often say when we start these sessions that because we tend to do them on a 3-monthly basis, and because case law tends to develop quite slowly, and of course because novel and new things don't come along that often, we don't tend to have that many new things to discuss. Yet I end up speaking for 50 minutes anyway. This time, genuinely, actually, there is only a few cases for me to share. However, as I'm sure some of you will already be aware, if not all of you, one of them is quite significant, although quite how much there is to say about it at this point in time, I'm not sure. So let me just share my slides. It's that one, and then let's from beginning. Okay. Hopefully everybody can see that. Can you nod, Claire? No?
Yes, now we can.
Yes.
Yeah.
Smash them. Okay. So, as I said, obviously the first significant matter, very significant matter, was the Supreme Court's judgment in For Women Scotland versus the Scottish Ministers. And the outcome of that was, contrary to what some newspapers might be trying to tell you, simply the fact that trans women, and indeed trans men as a result, with gender recognition certificates do not qualify as the sex for which that gender recognition certifies them for the purposes of the Equality Act. Obviously, lots of things you will have seen in papers and online and in plenty of other places was claiming that the Supreme Court was saying trans women are not women, trans men are not men. No, specifically and explicitly in the judgment, the Supreme Court were very explicit that they were saying for the purposes of the Equality Act 2010, if, for instance, a trans woman holds a gender recognition certificate saying that they are a woman, that doesn't mean that they benefit from protections under the Equality Act as a woman. Okay, so that means that they could not bring a claim on the basis that they're being discriminated against on the grounds of their sex because they're a woman. What they could do is bring a claim in relation to their transgender status. That, of course, still remains protected under the Equality Act 2010. As I say, their protection on the basis of that protected characteristic remains. What we are waiting for, we currently have interim guidance from the Equality and Human Rights Commission. That's not statutory, it's interim guidance. And in actual fact, if employers and particularly public bodies want to ensure that they are acting within the law, they still really need to be looking at case law because that guidance is not statutory. What we are waiting on, is the HRC's formal final guidance. We're not expecting that anytime soon. The rumours swirling around is that that is not going to come until the current chair of the HRC steps down, which could be for some months yet. Now, the issue is the HRC, some of the comments that have come from the chair seems to be tying itself in knots somewhat. There were some statements to a select committee the other day that the chair made stating that Article 8 of the European Convention on Human Rights doesn't apply to trans people in the workplace being questions about their gender status. That's surprising because the Gender Recognition Act is essentially predicated on Article 8, so that would cause them some issues. It wouldn't surprise me when that guidance comes out if there are quite a few significant legal challenges from trade unions, from entities like the Good Law Project. I don't know, we'll have to see because we are waiting for that guidance. One thing I would say though is that we are already seeing some impacts from this outcome, and sadly there are impacts that were predicted. One of the things that you might note is this is for Women Scotland, and they brought the claim specifically querying about trans women with a gender recognition certificate. Now, the outcome affects both trans women and trans men, but the claim was structured around trans women. And that is because the people who are interested in pursuing these cases and who are so offended by the existence of trans people tend to be focused heavily on trans women, not so much trans men. And one of the impacts that was predicted before this result came out was obviously one of the things For Women Scotland was saying was, well, this will mean that trans women who they regard to be men will be able to use women's facilities, and that's not acceptable because all sorts of reasons, which I won't go into, which I don't personally agree with. But anyway, the point is that they didn't consider the fact that, of course, the opposite, if they win, would mean that trans men who have been transitioned potentially for a long time and who are passing in the community and who everyone knows as a man would then be forced to use a male bathroom. And in fact, we're aware from anecdotal reports that those cases have already started arising. And in fact, the NASUWT have already got one on their hands where we have a member who is a trans man who has been living as a man for, I believe, over 30 years, who is known to everybody he knows other than some very intimate partners and people, immediate family, as a man. And he's now being told by his workplace that he is to use the women's bathroom in light of this judgment. And that, of course, is not only going to cause him an awful lot of concern, it's presumably going to cause the people who brought this case, or should be causing the people who brought this case, a concern, because that is a man in your bathroom. So yeah, this is a whole mess, to be honest with you. We're going to see what the HRC guidance says. I doubt it's going to be capable of resolving the issue satisfactorily. And as I say, as a result, there will be legal claims. And of course, we'll continue to support our members who raise these issues with us. So that is all there really is to say at this point on that particular issue. I'm actually unable to read the title because, annoyingly, I've got this bar up at the top. Campbell, there it goes. Campbell versus Sheffield Teaching North Hospitals and Hammond. This is a decision by the EAT. I thought this one was somewhat interesting because I thought the outcome, although logical, might initially be surprising, but it is logical. It's because of the way the legislation is written. And secondly, actually, it involves union members and a union representative. So this union member brought a complaint of racist or racial harassment to the employment tribunal. Initially, it then went to the EAT against their employer because they suffered some racist abuse, racist harassment by a colleague in the workplace. However, that conversation in the workplace was being carried out between that claimant, who was a union member, with their union rep, who was also an employee and a colleague. So yeah, the member brought the claim against the employer because that union rep was a colleague. Therefore, they claimed it was work related, essentially. And the racist comment itself was admitted by the individual who made it. They said that they made it in the heat of the moment in an argument. Not that that is an excuse, but that's how they admitted it. The EAT found that it was not racist harassment for two reasons. First off, that it wasn't a work-related matter. It occurred during working hours in the workplace, but the conversation was specifically about union business. It was about membership. It was about, I think the claimant wanted to leave or something like that. And secondly, and I thought this was the more interesting bit potentially, that the employer had demonstrated that it had taken all reasonable steps in order to ensure that its employees were not racist or abusing each other in a racist manner within the workplace. They had training, they had monitoring, those things were regularly repeated, it was recorded that those things were happening. They had literature around the place. It was clear that this employer was doing all that it could to ensure that its environment was not a one where you might experience racism. Now, when I say doing all it could, the point is, when you construct a claim such as this, if you are saying that the employer is at fault, you need to be identifying what you think they should have done that they didn't do. And that, it appears, is what the claimant failed to do here, because the EAT reasoned that the employer had demonstrated a number of steps which it had clearly taken, it had evidenced them, And the claimant had not suggested any other steps that they should have taken, which they didn't. And as a consequence, if you consider those two statements, you have to conclude that the parties were satisfied that the employer had taken all reasonable steps. So consequently, the employer was not liable for that racist abuse, and it was not work related because it was in relation to union business. Now that bit does surprise me a bit, because we all have all sorts of conversations within the workplace which are nothing to do with work. Of course, you know, I'm heavily committed to my work, and 95% of the time I'm doing things which I should be doing. But 5% of the time I might be discussing the football. I might be, well, I won't be discussing the football. I'm not interested, but you get the idea. I might be discussing something which is not strictly work related. And if I were to abuse a colleague during that conversation in a racist manner, it seems that this judgment offers a defence that, yes, it was in the workplace, it was during working hours, both of those individuals are colleagues, yet the conversation was not strictly about work-related things. It seems to fly somewhat in the face of previous cases we've had where we would have an incident occur at a Christmas party. It tends to be the classic. We get a lot of them around December, where all work colleagues are out. They are all drinking. They're presumably not talking about work-related things, but one colleague will sexually harass another colleague. Now, in that situation, the argument generally has been in case law, well, that is a work-related event because it's only occurring because all these individuals know each other through the workplace. It's an extension of the workplace because it's a workplace social for people to get together, get on better, know each other better, etc., etc. But those people presumably are not talking about work all the time there, which would seem to fly in the face of this judgment somewhat. So I wonder whether case law is going to slightly change on that now. It's not just about where you are or whether that event is work related. It also has to be about whether the discussion that was ongoing was a work related one. It may be that in this case, because the discussion was explicitly about union business, which is obviously in a way explicitly separated from work-related business. That's why this case was found in the way it was. But I thought it was an interesting one nevertheless. This is in relation to part-time worker detriment. So Augustine versus Data Cars Limited in the Court of Appeal. So a part-time taxi driver brought a claim of part-time discrimination or detriment against their employer because the employee paid a flat weekly fee to the employer, essentially to secure a certain route for themselves or a certain area. Okay, and the fee that they paid was the equivalent fee that full-time colleagues paid. Okay, now it was found that this was not part-time detriment. And the reason for that was that there was a test set out in another case in Scotland, McMenemy versus Capita Business Service, where that court found that being part-time is not the sole reason for the treatment, i.e. it's only part of the reason for the treatment, then it's not part-time worker detriment. In this particular case, the reason why the individual was being charged a high fee was not just because they were part-time. The employer, Data Cars, said that it was because the council charged them a certain amount every year for use of that area. They licensed it from them essentially. And so the fee had to be set at a certain level, regardless of your hours, for them to be able to cover that license arrangement with the council. Consequently, the Court of Appeal found that there were two reasons for the treatment. One was because the individual was part-time, but the second was because of the amount of money that the car company or the taxi company was being charged by the council. And because the reason for the detrimental treatment was not solely the part-time status of the claimant, the claim fell. Now, the Court of Appeal made clear in this case that that was not a satisfactory outcome, and they understood that, but that they were bound by the previous judgment. Consequently, they are recommending the claimant appeals to the Supreme Court because currently there is essentially a gap in protection for part-time colleagues. If they are being treated poorly by a school, but if the school can give more than one reason why they are being treated in that way, even if one of those reasons is because they are part-time, then currently case law binds any court other than the Supreme Court to find that that is not part-time worker detriment. Hopefully that is going to be appealed to the Supreme Court. I hope and I suspect that somebody is going to take that on pro bono for him because You know, a part-time taxi driver probably doesn't have the cash to bring a claim to the Supreme Court. But given the fact that it is setting an unhelpful precedent for part-time workers presently, I'm sure some learned barrister will want to be taking that up and rectifying that issue. So yeah, that's the end of the somewhat helpful case law updates. There were a few others, but they were kind of limited to technical things, stuff about jurisdiction of the tribunal, things that really I doubt they're interesting. Maybe they are interesting to you if you're like me, but really it's for things they would be things that us in legal would deal with if we're taking a case like that. So I thought I'd touch on the Women Equalities Committee report on parental and shared paternity and shared parental leave. So the Women Equalities Committee is a parliamentary committee. Because we have the upcoming Employment Rights Bill, which talked about its intention to address or look at the very least, paternity and shared parental leave. And this is all sorts of parental leave, by the way. The Employment Rights Bill is talking about looking at whether that's unpaid parental leave, whether that is maternity pay, etc., etc., etc. The Women and Equalities Committee released a report looking at provision in the UK. And they identified an awful lot of issues, and I've highlighted a few of the key ones there. The fact is we have very low rates of statutory pay associated with any sort of leave, parental leave, maternity leave, paternity leave. We rank close to the bottom in Europe, particularly, and this touches on the second point, when it comes to paternity leave. 2 weeks of statutory pay is the maximum entitlement under stat. The other point, sorry, I should make in relation to the very low rate of statutory pay was the Women and Equalities Committee pointed out that the rate of statutory pay is so low and has failed to keep track of inflation for so long that it is half the recommended national living wage. That's the point where we've got to now. And also that the system should take into account, in the view of the Women's Inequality Committee, making accommodation for single parents or parents of multiple births. Of course, if you have twins or triplets, or God forbid, any more than that at the same time, you're going to end up receiving the same amount of time off. You're going to end up receiving the same amount of pay. I don't think anyone is necessarily suggesting that if you have triplets, everything triples, but of course, maybe there should be some provision in there to take account of that. The fact is, of course, that, you know, what does our current system say? By paying men very little, we're saying we're expecting women to do the majority of the care. That is, I mean, it still is the case. It's becoming less the case, although not perhaps as fast as some might like it. Personally, I provide the majority of the childcare in our family. It's more of a common thing these days, but it's difficult when, of course, the statutory position is 2 weeks paternity pay for men and significantly more for women. It says we expect the women to do the caring, and that obviously is not right. So the key aim, concluded the Women's Inequality Commission in their report, of any review in the employment right, or any changes that come through in the Employment Rights Bill, should to be incentivise greater gender equality, as well as enhancing benefits all round. But the key aim should be enhancing that gender equality so that people can choose. One of the things that came out of the report was that whilst shared parental leave is an absolute mess of a piece of legislation and very difficult to get your head around sometimes, the fundamental principle of being able to share leave between partners is one that is appreciated by employees. And we can certainly see that in the union. It's popular amongst teachers because teachers are able to work during the holidays, go on shared parental leave during term, go on another period of work during the holidays, and structure their leave like that in a way that's very useful to them. So hopefully this report will be taken on board when it comes to amending and drafting the final Employment Rights Bill. Use of AI in proceedings. I've got a lot to say about this. It's something of an interest in mine and something that I've researched and looked into in relation to work. So these are two non-employment related cases, R versus Haringey and Al Hurun versus Qatar National Bank. However, they address a concerning issue that's been arising lately, one that you may well have seen, or fellow caseworkers that you know may well have seen already. We have certainly seen it in the office already. Regional officials have certainly seen it and have talked to me about it. So these two cases were essentially reviewed by the courts and have been referred to regulators and to the bar, to the solicitors' regulatory authority. Because in these two cases, the solicitors, and in one case a barrister involved, was found to have submitted pleadings and evidence which contained non-existent cases, misstatements regarding the effect of various legislation, citing non-existent authorities as well as all irrelevant authorities, and the courts were not impressed. As I say there, the lawyers and the barristers referred to the professional bodies. And I've seen it on a number of occasions, ROs have seen it on a number of occasions, where either members will come to us initially and either openly or not so openly say, I've spoke to ChatGPT and they've told me I've got a case, or alternatively, we'll tell them what we think of their case and they'll come back and say, oh, well, I think this. And it's all written in a very particular and obvious way, i.e. AI type. It's problematic for a number of reasons. You will have noticed I've put quotation marks around AI, and it is infuriating that the BBC, the Guardian, other supposedly respectable publications call this AI. The fundamental issue is it is not AI. There is no intelligence there. It is a large language model. What that means is it predicts what word it thinks it should come next in a sentence, a string of words, based on what words came before it. And how it does that is it looks at huge volumes of data, sentences that have come before that it's been fed, and therefore it can predict what word should come next. So it can only tell you what has been put into it. It can't come up with anything novel. These AI are also programmed to satisfy their user. There was a big hoo-ha a few months ago where ChatGPT, the most recent model, was altered so that it was more receptive and more open to its users. And the users were all complaining that it had become incredibly sycophantic. It will tell you exactly what you want to hear. And so if you ask it whether you've got a legal case, it will make up a case to support your case. It'll make up case law. It'll misstate the effects of law, and it will attempt to please you. It'll tell you what you want to hear. And so this has become an issue not only in legal cases. I read about an instance, it must have been about 6 months ago, where I'm not sure if you might or might not be aware, on Google there is a whole industry of individuals who are selling books which they have been written by AI, and they're rubbish, they're slop. But the fact is the AI can churn out hundreds of them a day. And so if you can get them printed, and if you can sell 1% of your inventory, because your costs are so minimal, because you're getting AI to write the thing, you can make a profit doing this. There are actually courses out there teaching people how to do this. And what happened was somebody generated one of these books, and it was a book on identifying edible mushrooms. And you can guess what happened from there. The AI wrote a load of nonsense, misidentified various different types of mushrooms, made up a whole load of others, and somebody was seriously injured, made seriously ill by following the advice in that book. So the fact is, fundamentally, this whole AI hype is currently marketing, and a lot of people are falling for it. It has some uses, and I have no doubt maybe 10 years down the line it might be more useful. But we're being sold a lot of hype by a lot of people who have an interest in selling these systems. And I am concerned that in 10 years' time, we'll see a post office style scandal if a large company or even the government adopts one of these systems to perform some vital function. So I'm starting to rant now because it's one of my interest areas. But fundamentally, what I'm saying to you is, if you suspect or if you know that a member is asking you to provide opinion on some AI opinion on their case or situation, obviously don't be dismissive of the member, and I'm not suggesting you would be, but feel free to be dismissive of the advice. It is not good practice to be using AI for these things. They are not accurate. Question and answer session.
Brilliant. We've got 1, 2 now questions in, but I'm going to take advantage as chair as I can. You know that one about the union rep and taking his employer to court?
Yes.
Would he, could he, should he have been taking the union to court? Is that something that...
Yeah, it's possible, because obviously the union will certainly, much like we do, have a constitution, and it will have rules, and it will have codes of conduct. If they're being abused by someone in the union, it's perfectly possible to bring a claim against them. Yeah, absolutely. Not that I am aware of any instances of it actually occurring, but I'm aware that members have instigated proceedings against us in the past. I'm not aware of any that have been successful or have been genuine or backed up, but it is possible, yes.
Yeah. It would have just made more sense that way around for me, rather than the employer, but I don't know. Anyway. Okay, Karen's asking, does the AI issue have a more generic negative impact on teaching? For example, using AI to write notes and or lesson resources, etc. If they're wrong, does that then feed into the erroneous pit of wrong info that's been used for AI generated material?
Yeah,
Does
absolutely.
that make sense?
Yeah, I think the fact is, as I said, whilst I think we are being fed a whole load of marketing nonsense, there are some uses for it. Collating your own notes, for instance, is a good use for it. So if you have written copious things that you know are yours and are true, you can tell AI, please review this document and provide me with a summary. And if you know those notes already, that is a useful way of getting a useful summary. But the fact is, if you're asking an AI to do anything where it is acting under its own initiative and you are not certain about what is being fed into it in the first place, you are going to have to exhaustively check that document to make sure that what it is referring to is correct. And that can almost take you as long as doing the job itself.
Mm.
So the fact is, there can be uses for it, but ultimately it's a dangerous thing to do, I think. And if ultimately a teacher, for instance, is using AI to produce resources for the classroom, and it turns out there's an error in those documents, then ultimately the teacher is likely to get in trouble for that. So yeah, it needs to be careful.
Yeah. Okay. Rob's saying he's really interested in the trans man casework you mentioned. Outside of the presumed argument that the EHRC is just guidance and employers don't need to act on it, are you using the Equality Act protections for trans people in that presumably it puts them in a very uncomfortable position? Also, you mentioned the right to privacy. I'm guessing many staff do not and did not know you was a trans man, so are there arguments there too?
Yeah, I mean that's an incredibly incisive question, which of course is a always a precursor to me saying we're not quite sure what we're going to do yet.
Mm.
The fact is that this is a very fresh development. It's a potentially very troubling development. And it's also an area where, as I pointed out, the AHRC and the courts are going to find themselves tying themselves up in knots because there are going to be these contradictions between these
Mm.
rights and these expectations. And as a consequence, the advice that we received, we went straight to a barrister who has come back and has essentially said, because this is such a fresh issue, we intend, I would suggest that you are going to bring claims on the basis, and I'm reading here, of gender discrimination on the grounds of gender reassignment, harassment related to sex and gender reassignment, indirect discrimination contrary to Section 7 and 19 of the Equality Act, which again is sex and gender reassignment. We're going to bring the same claim under multiple different heads because essentially we're going to have to ask the court, you're going to need to provide guidance here.
Mm.
And you can guarantee that first tier court decision, if and when it comes, whether it's from our case or from somebody else's, is going to be appealed to the next level. It's going to be appealed to the next level. It's going to be up to the Supreme Court, most likely again, to make a decision. And that may take years because the Supreme Court, not every case can be appealed multiple times. You have to apply for permission to appeal. The courts may decide that it's not appropriate in that instance. Even if you got a case, our case that's ongoing right now, if you're talking about that getting to the Supreme Court, that's 2-3 years away in ideal circumstances. So the sad fact is, yeah, we are going to use, we're going to get advice and we're going to use that advice to see what elements of the Equality Act we think can be used most effectively to protect these individuals. It is probably going to be bringing cases under the protected characteristic of transgender status, but ultimately we can't be certain right now. It's all up in the air.
Yeah. Olivia, you put a question in. Can you be a bit more specific, please, so I can ask Nick directly because there is lots of case law around LGBTQ issues. So, what in particular are you looking for there? Craig's got a comment, not a question. He said HR there are increasingly using the Microsoft Teams AI transcription tool, and it was a good job he checked it at one point, having quoted him as saying the total opposite of what he was actually saying.
Yeah.
And yeah,
Yeah. I was saying this. I am concerned, and this is why it's such an interest of mine, that we are entering a perfect storm here,
mm,
whereby HR and other, entities within businesses generally are looking to cut costs, and they are being sold this product as an amazing way to cut costs. Now, putting to one side the simple impact on jobs and the availability of jobs for people, the fact is that they are not. Suitable at present, but they are very appealing. And as a consequence, HR is jumping on them. I keep getting emailed by Daniel Barnett, who's a barrister who likes to send out updates, but also provide training, constantly giving us emails about, you need to use AI in the workplace, how you can safely use AI in the workplace, AI is coming, etc., etc., etc. We need to take a step back and take a breath, because it is not fit for purpose at the moment.
No.
And we shouldn't be calling it AI, quite frankly. It gives it far too much credit. So, yeah.
No, I had to do some policy negotiations with some HR provider, and they were saying, well, we're going to run it through AI. It's like, well, no, you're not going to run it through AI, because we are the professionals and we know what we're doing. It was just ridiculous. Liam's asking, is there any casework with teachers being accused of malpractice due to pupil-created work for exam boards and the centre then being under scrutiny for submitting it for moderation?
Liam, if you wouldn't mind to just type in yes or no, is that in relation to AI? Because I'm assuming you're saying what pupils creating work via AI for exam boards, because, oh, I think you just said yes or no, sorry. Yeah, at present, I am not aware of any. It wouldn't surprise me if there is. Certainly, it's something we could ask caseworkers. Nothing has come across my desk, and also I suspect nothing has yet come across legal's desk. Because if that had happened, I suspect we'd be chatting about it. All our colleagues are currently having this conversation about the fact we keep getting members coming into us with AI's opinions on their situations. But it wouldn't surprise me if there are caseworkers locally who are dealing with it. The fact is, in that situation, it may not even come across legal's desk, because, of course, legal are always here to assist colleagues if they have particular questions. But ultimately, sometimes they are experienced enough, or the question is clear shut enough that they don't need to refer it into us. And if a pupil has submitted AI generated coursework to an exam board and has been pulled up on it, so long as our member is not being pulled up for it and they've done everything right, and the school is not implying that they haven't, then it wouldn't even come into legal. But I have no doubt that it's happened. Yes, certainly.
Okay. Okay, Olivier said, this is around the case law around LGBT issues. He's asking whether there's case law regarding harassment, bullying, and what would be the case law we would use to protect our LGBTI teachers.
Sure. I mean, the difficulty is that there are so many potential. Every case is infinitely different to every other case. And as a result, there are thousands and thousands of pieces of case law. And so it depends 100% on the facts of that individual case. If someone comes in and says, I have been abused on the grounds of my sexuality, this is the form the abuse took. This is how long it went on for. This is the response of my employer. These are all factors which would make me think, okay, can I think of a piece of case law, or can I search for a piece of case law which fits those facts and can find something useful? So the answer is yes, there is, but there isn't one go-to piece, or even a dozen go-to pieces. It massively depends on the facts of the individual case. So yeah.
Now, I don't know how much you know about AI and the ways that we can identify it, but I'll ask you anyway. Would systems such as Turnitin identify AI produced work?
Not necessarily. I do know a bit about this. I am aware that again, part of the problem here is, and I'm talking about with Turnitin, not just with AI systems themselves, is that we're sold a lot of marketing and they're not generally as good as they suggest they are sometimes. I'm aware of at least one instance where somebody fed work into Turnitin that they themselves had done in order to see whether it would identify it as AI or not, and it came back saying it was more likely AI than not. So the fact is, then the problem is, you see, is that these AI systems are constantly evolving and changing. The new iterations of them are brought out about once every 6 months or so, sometimes faster. And even when those iterations are out, the algorithm behind them is tweaked on a regular basis. Hence, I talked about that specific example where people were getting upset that I think it was ChatGPT had become totally sycophantic. That was a mid-model update. So those tools, I don't know how much use they are.
Karen was just, well, this is kind of what Nick's already commented on. Karen, how would a member know if a student had produced work using AI? And that's the point, isn't it? We need to be making sure that if a student has produced work using AI, that our members done everything they can to identify that and deal with that situation.
Yeah, I mean, at present, so the problem is, the more laborious way of doing it, and you won't have time to do this,
Mm.
would be if you're because much like with the case law and the lawyers submitting made up case law in a tribunal claim, if a student is submitting an essay which has got something, you know, which is quite heavily fact related, psychology, referring to previous studies. It wouldn't surprise me with something like that if AI is going to trip up and make up a case study. But as a teacher, you cannot be going through and double and triple checking every single sentence to make sure that something hasn't been made up in there. However, what you can do at present is these AI models have a very particular way of writing. It is identifiable, right? If you were to spend literally a couple of hours reading through lengthy AI responses to questions about history. You don't even need to use ChatGPT yourself. You can find examples of them on social media. Okay, you can quite quickly get used to the way our AI writes. It's in a very particular style. I can't really describe it to you verbally, but you can identify an AI bot on somewhere like Reddit quite easily. Um, the fact is, the problem is, rather, as I said earlier, these things are moving very quickly. And despite the fact AI is not good at coming up with novel arguments or correctly identifying the law, what it has rapidly got better at is sounding like a human. And that means that soon that method of knowing what AI sounds like will not be a valid method to identify whether something is AI or not. So the fact is, what we need to be doing as a union is we need to be talking to schools and talking to trusts and talking to the government about the fact that once AI reaches a level where it is impossible to tell whether they are uh, whether a student has used AI or not. A teacher cannot be held responsible if it subsequently turns out that work has been submitted as AI, so long as they haven't been negligent in some way and not done the most basic of checks. But I don't even know what they'd be if AI got that good. So ultimately, and you know, this is pie in the skyland, the ideal scenario is the government has to come up with some sort of solution. They have to have some sort of system or process, which they or the regulator or whoever it is or the exam boards themselves, and they say, well, this is how we're checking for AI, and you run it through these checks, and if it passes through, the buck doesn't stop with you; it stops with the exam board on that basis. But it's an intractable question. It's really difficult. This sort of stuff is very, very popular with the kids. And at present, I would say it's possible to identify it at eye after having a look for an hour or two, but it's not going to stay that way for long.
Mm. Well, you'll be happy to know, Nick, I've never used AI. I wouldn't even know where to start. I wouldn't even know what to type in to get to it. So there you go.
I mean, it's fun to use. It's fun, but that's the problem. It's not useful at the moment for
Mm.
technical or even slightly complicated things. I've used it a bit because I'm interested in it. But I'm interested in it because it's weird and it's fun. It's not good. I mean, I wouldn't dream of putting it anywhere near my work because it would be a disaster. It'd be a total minefield. But yeah.
Well, there's no more questions for you, Nick.
Thank you.
So it looks like we're going to go for an early lunch. Thank you again for your time, Nick. It's always really, really interesting, really informative. We look forward to having you at the next session as well. So thank you very much.
Okay, thank you. Bye-bye.
Bye. Okay, everybody, we'll take lunch now. Back at 1:30, she says, looking for a thing. Yeah, back at 1:30 for the final session of today. So see you later.